I call Claire Curran.
Thank you, Mr. Speaker. Every time there's a disaster in our country, the community involved pulls together and is, of course, supported by the rest of us. But those of us who aren't affected or less affected can only offer support and aroha, and in some cases, practical support, and it can be quite difficult to stand on the sidelines and watch the pain of people in those communities. Sunday night affected almost all of us, but as we know, the people of Kaikoura, North Canterbury and Wellington were most affected, and the recovery for them will be tough for those people and businesses. And our thoughts are all with you today. We know that most people in New Zealand probably therefore won't be watching the third debate, the third reading of this particular bill, but having sat through many long hours on the Select Committee and being quite astonished and appalled really by the process that unfolded there, I think it is very important to have those it recorded in the Hansard of this House the impact of poor process and poor governance in a piece of law that goes through our House, and it should not go unremarked. It really annoys me, Mr. Speaker, that a member can get up in the House and to be honest, disingenuously try and minimise what was actually a catastrophe of a bill that came before a Select Committee and ended up coming back to the House almost gutted by a large percentage. And the fact that members who also sat on that Select Committee can diminish the importance of that, it's no wonder that people are disillusioned with politics and politicians when that honesty can't actually be there. And I think it's important that we do dissect it. And I know that colleagues on this side of the House, particularly those who sat on the Select Committee, have done that today. Because it was unusual and it was disappointing and it was time wasting and money wasting to have a piece of legislation that had been so poorly prepared and poorly thought through before it came to the House. The Labor Party, I think I said in the committee stage that the Labor Party did the government a favour by agreeing and voting for the amendments to this bill at Select Committee, because if we hadn't, and if we'd been joined by the other opposition parties, then the bill coming back to this House would have been the bill that we had discovered was actually being recommended against by the officials who had actually put it in there in the first place. And this, of course, relates to the significant part of the bill on the inclusion of a single application process and a single examination process for a new way of creating patents that was not only out of date, because there is already a new international process being developed through the World Intellectual Property Office, but would also have been much more costly. And when we forensically required the officials to go back and tell us what the cost-benefit analysis, if one had been done, and on what basis it had been done, we discovered that those costings, described as guesstimates and back-of-the-envelope costings, were going to be in the order of around $500,000 for an application process, which, when we considered that, seemed to be somewhat exorbitant and inefficient, and went against the original intent of the bill, which was to streamline a process. And I suppose the point is to make that this is not a major piece of law, and so therefore what we're arguing about and what we're pointing out is not the biggest boo-boo that the government has made, but it's enough of a boo-boo and it's, I guess, indication of a trend of legislation that comes before Select Committee that has not been properly looked at and thought through and tested before it actually gets to Select Committee, but it's enough of it for us to be severely concerned. And I agree with my colleague David Clark, who said it really does show, it reflects back on the ministerial leadership. And yes, you can blame and hold the officials to account, some of the officials to account, and I think we've done that, and I think it's, we've done that enough. But ultimately, the buck stops with the minister, is that if he hadn't read it properly, he didn't understand the implications of it, if he hadn't asked the proper questions about the basis on which this new patent process was being put into the bill, then perhaps it wouldn't have come before the committee in the state that it had. I mean, it never even went through a proper pre-legislation process, or the process it went through. The clear indication was that it wasn't going to work, but it still got pushed through, and it ended up getting dumped. And luckily for the government, the opposition actually agreed to amending it, to taking out that large piece of the legislation at Select Committee, which means it's come back to the House. This piece of legislation almost does nothing, which is why I say it's not a major piece of legislation. It really is a bit of a non-piece of legislation now. It does streamline the patent attorney, the way that they're trained and the way that they operate in Trans-Tasman, and we've done that with other industries, we've done that with accounting, but this really is not groundbreaking or earth-shattering. It could have been an innovative piece of legislation if it had actually if they'd done the work properly. There was a piece of legislation in 2013, which was the reform of the Patent Act 2013, that did go through a very lengthy, robust, controversial process of a number of years. That was a major reform of a piece of legislation from the 1950s about whether our whole patent law needed to be reformed. And yes, it did. It needed to be reformed and modernised and updated. The most controversial part of that was what it didn't do, what it ended up not doing, which we thought was in the best interests of our innovators, and that was to make software patentable. So there was an exclusion given for software, which in effect meant that software which still had copyright protection, still has protections for intellectual property, but if we'd made software developments patentable, that would have resulted in the major tech companies that are based offshore coming in with big patent suits, locking up innovation from our small innovators, and also unleashing the force of the patent trolls, which are a hideous industry that feeds off the ideas of others and holds up innovation. We did a good thing with that, and that ended up being a unified approach across the House that had the industry and the innovation industry very engaged, and I think was one of the best decisions made in this kind of legislation for a long time. This piece of legislation is really a joke, and it's embarrassing. I think it was described as sloppy and unedifying in Labour's minority report. The Minister, Paul Goldsmith, really should learn a lesson. We hope that he will learn a lesson, and next time a piece of legislation from him comes before the Select Committee, that he will have done the homework required before it gets to the House for first reading and comes before the scrutiny of the Select Committee. I do acknowledge the work done by the Chair, Melissa Lee, other members of the committee. The heavy lifting, to be honest, though, was done on the opposition side, but I do acknowledge the chairmanship of Melissa Lee in this bill. Looking forward to the next piece of legislation from Paul Goldsmith, because I don't think the bar could be much lower.
I call